Good evening, friends. Let us talk about new case law, which is in the Advocate on Record and has been recently added in the syllabus. I am talking about in reference Article 370 of the Constitution, which was decided on 11th December 2023. The bench constituted includes Honorable Chief Justice D.Y. Chandrachud, Honorable Justice Sanjay K. Kaul, Honorable Justice Sanjeev Khanna, Honorable Justice Bhushan R. Gai, and Honorable Justice Surya Kant. The question which was to be decided by this constitutional bench is the Union of India's abrogation of Article 370 of the Constitution of India and bifurcation of the state of Jammu and Kashmir into two union territories constitutional. Now let us go into the factual background. Friends, prior to 1947, the territory of Jammu and Kashmir, shortly J&K, was ruled by Maharaja Hari Singh. When India gained independence in 1947, J&K had to choose whether to join the Dominion of India or Dominion of Pakistan. Faced with a military threat from Pakistan, Maharaja Hari Singh joined the Dominion of India by signing an instrument of accession in 1947. In June 1949, the Maharaja transferred his power to Yuvraj Karn Singh. In November 1949, Yuvraj Karn Singh made a proclamation that the upcoming Constitution of India would govern the constitutional relationship between J&K and India. When the Constitution of India was adopted, J&K was included as a state in the Constitution. However, the entire Indian Constitution did not apply to J&K. In 1957, the Constituent Assembly of the Jammu and Kashmir prepared and adopted the Constitution of Jammu and Kashmir, that is J&K Constitution. The relationship between Indian government and JK was set out in Article 370. Article 370, Clause 1 allowed the Indian Parliament to make laws for the J&K subject to the consultation or concurrence of the JK state government. Article 370, subclause 3 allowed for the violation of Article 370 and entire Indian Constitution to apply to J&K if the President passed a constitutional order, that is shortcut CU, on the recommendation of J&K Constituent Assembly. However, the J&K Constituent Assembly was dissolved after it adopted the J&K Constitution, and no recommendation was made for the removal of the Article 370. In June 2018, the Chief Minister of J&K resigned, and in November 2018, the Governor dissolved the Legislative Assembly of J&K. 1 month later, President's rule was imposed in J&K under Article 356 of the Indian Constitution. Under President's rule, the governance of the state was transferred to the President of India and the Indian Parliament. In August 2019, the President issued Constitutional Order 272, which applied all the provisions of the Indian Constitution to J&K. Constitutional Order 272 also stated that Article 370 could be removed on the recommendation of State Assembly instead of J&K Constituent Assembly. The President then issued Constitutional Order 273, which abolished Article 370 on the recommendation of Parliament, acting as the state legislature of J&K due to the imposition of President rule in the state. Finally, Parliament passed the Jammu and Kashmir Reorganization Act 2019, shortly J&K Reorganization Act 2019, which bifurcated the state of J&K into two union territories, the Union Territory of J&K and Union Territory of Ladakh. The petitioners challenged the constitutionality of Constitutional Order 272 and Constitutional Order 273 and J&K Reorganization Act 2019. Now, decision of the Supreme Court. Honorable Supreme Court rejected the petitions and upheld the violation of Article 370 and the reorganization of the state of J&K into two union territories. The judgment of the court was authored by Honorable Chief Judge Chandrachud. Justice Sanjay K. Kaul and Justice Sanjeev Khanna wrote separate concurring opinions. The Supreme Court found that Article 370 was a temporary provision enacted until the special circumstances facing J&K were resolved. The court held that the President could not use a constitutional order to indirectly amend the Constitution to make the removal of Article 370 conditional to the recommendation of state legislature instead of J&K Constituent Assembly. But it also found that the recommendation of the J&K Constituent Assembly under Article 370, subclause 3 would never have been binding on the President of India, who always had the power to remove Article 370. After the dissolution of the J&K Constituent Assembly, the President could abolish Article 370 whenever the President thought appropriate. The court also held that the passage of the J&K Reorganization Act did not violate the procedure for the reorganized states as per Article 3. The Government of India stated that the Union Territory of JK would be made a state again, and that the court did not decide the legality of converting the state of J&K into two union territories. The court directed that the election to the Legislative Assembly for the Union Territory of J&K be held by 30th September 2024. Now let us, friends, explore the reasons for the decision. Now, first one is Kashmiri sovereignty. Honorable Supreme Court held that after Maharaja Hari Singh signed the instrument of accession and Yuvraj Karan Singh made the proclamation stating that the Constitution of India will govern the constitutional relationship between J&K and India. J&K became an integral part of India with no separate sovereignty. The court also noted that Section 3 of the J&K Constitution said that J&K was an integral part of India, and Section 3 could never be changed by the state government of J&K. Thus, while the J&K Constitution and Article 370 gave J&K extra autonomy, it was still a state under the Indian Constitution. The separate opinion of Justice Kaul found that the state of Jammu and Kashmir attained sovereignty due to the J&K Constitution. Now, coming to temporary nature of Article 370. The Honorable Supreme Court found that Article 370 was originally passed as a temporary measure till the special circumstances in the state ended and the J&K Constituent Assembly was formed. Article 370 was included in Part 21 of the Constitution, which is known as temporary and transition provision with other temporary articles. The marginal note next to the Article 370 set a temporary provision with respect to the state of Jammu and Kashmir. Now, friends, let us explore difference between Constituent Assembly and state legislature. The Supreme Court found that one paragraph of the Constitutional Order 272 was unconstitutional because it tried to indirectly amend Article 370. Paragraph 4 of the Constitutional Order 272 stated that instead of the J&K Constitutional Assembly giving a recommendation to the President to abolish Article 370, the state legislator could make the same recommendation. The court held that a state legislature and constituent assembly are very different. One passes law and other creates a constitution. Thus, by trying to replace constituent assembly with state legislature, paragraph 4 of the Constitutional Order 272 was an indirect and unconstitutional attempt to amend the Constitution. Now, President's power to abolish Article 370. The Honorable Supreme Court held that President of India retained the power to unilaterally abolish Article 370 even after the J&K Constituent Assembly ceased to exist. Article 370, subclause 3, required the recommendation of the J&K Constituent Assembly to abolish Article 370 entirely. The court found that while concurrence meant the J&K state government had to agree with the Indian government, recommendation only required the views of the J&K Constituent Assembly be forwarded to the President under Article 370, subclause 3. Thus, the recommendation of J&K Constituent Assembly would never have been binding on the President. The J&K Constituent Assembly was dissolved after adopting the J&K Constitution, but the President retained the power to abolish Article 370 whenever the special circumstances in J&K ended and the President thought it appropriate. The court held that it can only review the President's decision to abolish Article 370 if it was made in bad faith, which it was not. The Supreme Court held the President did not need to consult the J&K state government to apply the entire Indian Constitution to J&K. It held that consultation was only necessary where some parts of the Indian Constitution were being applied to J&K, and careful amendments had to be made to the Constitution of J&K. But because the whole Indian Constitution was being applied to J&K in 2019, the Constitution of JK was being replaced entirely by the Indian Constitution. No consultation was necessary. After the whole Indian Constitution was applied to J&K, the Constitution of J&K is inoperative. Now, friends, consequences of President's rule in Jammu and Kashmir. The decision of 9 judges in SR Mumbai and Union of India had already held that President's decision to impose Article 356 in a state, that is, presidential rule, was subject to judicial review. The petitioners argued that Article 370 could not be repealed during the imposition of President's rule in J&K. The court rejected this argument and stated that government action under President rule cannot be rejected merely because it has an irreversible impact. However, the court also held that the actions taken during the imposition of President rule were subject to judicial review on the ground that they were made in bad faith or had no connection with the reason for imposing President rule. However, actions pertaining to everyday administration of state during President rule cannot be challenged. Reorganization of state into 2 union territories. Article 3 of the consultation allows Parliament to change the boundaries of the states by passing a law. However, any law made under Article 3, such as the J&K or Reorgan Act, must be sent to the affected state to seek its view. The Supreme Court found that the passage of the J&K Reorganization Act did not violate the Article 3 because the views of the state on any reorganization act are not binding. The requirement to seek the J&K views was suspended due to imposition of president rule in J&K. Parliament, acting as the legislator of J&K during the imposition of president rule, had agreed to the J&K Reorganization Act. The court held that during president rule, Parliament can not only pass laws on behalf of state, but also perform other constitutional functions for the state, such as approving reorganization acts. The Supreme Court observed that Article 3 of the Constitution gave Parliament the right to create a union territory out of the land of the state. The court upheld the creation of the union territory of Ladakh on the question of whether Parliament can extinguish a state and create two union territories. The court recorded the Government of India statement that the union territory of JK would be made a state soon again. Since this insurance was given by the Attorney General, the court held that there was no need to decide whether the state could be converted into a union territory. The court directed that election should be held in the union territory of J&K by 30th September 2024. The separate opinion of Justice Khanna noted that converting a state into union territory interferes with federalism and should only be done for compelling reasons. So this was all about this case. Friends, this is a very important case by my thinking. So revise it again and again so that you may get good marks in the coming examination. God bless you all.